I'll be brief, as I am at a loss for words. Now, it goes on to say here that I am deeply surprised after uncovering my husband's will. There is no provision for me as his wife. I am particularly surprised given the challenges I have faced alongside him. What steps can I take to address the situation and ensure fairness? How can the law help me? This is interesting.
Quite.
Yeah, it's an interesting one. First of all, we need to understand, and this must be emphasized, that you don't necessarily have a right as how a person decides to share or distribute his property after his death.
Okay.
Once a person has made that voluntary decision to make a will, he decides how he wants to share his property.
Okay.
So there is no legitimate claim necessarily that because I'm a son or I'm a wife, I'm entitled. However, if you look at our Constitution Article 22, for instance, it provides that there should be provision for spouses either on divorce or after death. So that alone gives spouses a leverage or some sort of a cushioning. Okay. So that if a husband or a spouse leaves you without anything in his will, there is something that you can do. Now, under our law, Section 13 of the Wills Act makes a provision for situations like this, where if you're a spouse, if you're a father, you're a mother, or you are a child less than 18 years, who is dependent on the testator during his lifetime, and that testator has not made any provision for you either during his lifetime or in his will, you can make an application for the court to make a reasonable provision for you, just so that you do not suffer substantial hardship or any hardship. But there are conditions under which you can go. One of such conditions is that you must make this application to the High Court within 3 years after the grant of probate.
Okay. Grant of probate meaning when the law has been read.
When the person dies, if Party A dies with a will, after his death, the executor's name in the will must apply to the court for what we call probate. That is authorization to go ahead and execute the terms in the will. So it is that probate. So after that application and it's being granted, within 3 years after the grant of it, you must make the application to the court. And it's not any kind of person who can make that application. If you are a nephew or you are a niece, you do not fall, because the law is specific. Section it says you are either a father, a mother, a spouse, or a child who is even less than 18 years.
I see.
Right.
Yes, very brilliant input. What I will add is the law says that your will must cover your self-acquired property.
Yes.
Okay. And so the property covered by the husband must be a self-acquired property. But if I heard you right, I think he said that they toiled together.
Yes.
Yeah. So
she said, I'm particularly surprised given the challenges I have faced alongside him.
Yes.
Which presupposes that they were in this together.
Yes. So the law today, or the law as we speak, now gives the spouses some ownership of properties jointly acquired, in marriage or things like that.
Yeah.
So if you can prove or you can show that the property was acquired during the substance of the marriage, and so it is joint property, then it does not only become the self-acquired property of the testator.
Okay.
So there's a case there to be made that this property cannot just go to that person because I have a portion or maybe a share, 50% or less or whatever, of that property. So that could be an interesting point we can deal with.
Wait, Shalom. So you're saying that if me, I've built my house with monies that I have made from my businesses, in the period that I am married to my wife, she automatically, without contributing a cedi in terms of cash, is part or joint owner of same property.
That's a general principle of the law.
That's the principle. Okay.
And the law has evolved over the years.
Okay.
From a place where the woman is only assisting the man in his station of work, and so he is fed and she's fed and all of that, to a point of what we call substantial contribution, which entitles that spouse to a certain percentage based on the contribution made, to a point of equity is equality, joint ownership. Now the law has evolved to the point where we say, okay, even though they may be married, the Constitution still provides an avenue for an individual to own property.
Okay.
As in fin and fin. All of that has happened. But the point is that once you acquire the property whilst you are married, the general principle is that it was acquired by both of you. So both of you are joint owners of that property. So my little point I'm making is that you can only dispose of that property to a third party in a will, for example, if it is your self-acquired property. So if I'm able to argue that the house you are seeking to will to your brother or your auntie or somebody, we acquired it together
when we were married.
Then I should be listened to, and I should have a case in there. You can say that you are willing your 50% or your share of that house to somebody. But as far as I'm concerned,
my 50%,
I'm a part owner of that property. So it may not matter necessarily whether you use money from your pocket directly to build. In the case of Mensa and Mensa, Justice Doche made Justice Doche made a point that the fact that the woman cooked for you, kept your home, and ensure that you were able to go to work to raise money to build, should entitle her to. So that's her contribution. Without that, you might not have been able to do that. So you cannot quantify that and say it's X amount of money. But there was a contribution made. And that's so important because it protects the woman. Because before a man dies, for example, family people come and drive out the woman from the house they have toiled to build together because they say our son built it. Not taking into account all that they would have gone through together to build a house. So it is to ensure justice for the spouses and also ensure that the law is fair to everybody. In the person's lifetime, maybe the person wouldn't have wanted that situation. But in this case, the person made a will and for whatever reason, willed it to somebody else when the spouse is there. The point Patrick made is brilliant, that where you have dependents, the policy rationale is that you won't have property but you will it to other people, and your own dependents will become a burden on the state. So because of that, if you will properties to other people and your dependents directly have not been captured, they can make a case to the law, and the law will find a way of giving them a good share or a share that is reasonable. And if that's like the only avenue that the court is able to change the will of the dead, because as much as possible, the will of the dead must stand. So the court is very hesitant in changing the will of the person, especially as the person is not alive, because nobody knows what went through the person's mind before or what consideration the person made. And the person is not alive to answer those questions. So as much as possible, the will of the person stands. So Section 13 of the Wills Act, which Patrick dealt with, is one of the almost like the only instance under which a third party or the court is able to change or vary the will of the person to achieve those ends of justice.
I see.
And to add, so in relation to Salom's argument of jointly acquired, except that the person in this instance has not specified the particular property in question. Her concern is that no provision has been made.
Nothing at all,
If that's the situation, then I am of the opinion that maybe her best decision would be to go under Article Section 13. But if she's pointing to properties that she thinks are jointly acquired property, these were properties we were acquired together during the substance of the marriage, then she can make an application under Article 22 and rely on the fact that this property couldn't have been disposed of to this person because this is a jointly acquired property that I have an interest in. And so then in that instance, then the court will then use this provision to change the disposition.
In fact, even under the New Lands Act, you can't even sell your land without the consent and not the knowledge and consent of your spouse. All of that is to make sure that the other side knows what's happening. Super. And of course, there are exceptions. If it's a gift, if it's a gift or something you inherited, that one, it was without the toil or assistance of the spouse. If I gifted you something, somebody else can't, it's not somebody's hard work. If you inherited something, somebody can't say, I toiled with you together. No, those are the exceptions here.